I do not like joint tenancy, and let me explain a few things about joint tenancy. We used to have it because it was popular to avoid probate duties. If you died, the survivor of your bank account or your property would automatically get your assets or that particular asset. So if my wife was going to leave everything to the dog home and she died, in her will, everything goes to the dog home. But because we own our property as joint tenants, I get 100% of the property. There's nothing she can do about it. No one can challenge that. They can challenge the will, but the property was not in the will because it was a joint tenancy property. The survivorship rules that goes to the survivor doesn't go through any wills. However, the capital gains tax regime treats all property as tenants in common, which means if you've got a cost base, you could well lose that cost base. So let's look at a piece of commercial property. You buy the property, it's a vacant block of land, it's commercial property, it's a residential home but you don't live in it, and you own it 50-50 with someone else. They die, automatically goes into your name. If it's a pre-1985 family home, you lose the pre-85 structure. So now it will become subject to capital gains tax, that half. And then when you come to sell it, you and you alone have to wear the capital gain. But if you had got rid of the joint tenancy, which does not trigger capital gains tax, and you don't lose your pre-1985 status, you get rid of the joint tenancy, make it tenants in common. When your wife dies, that half now goes into the will. You still get it, but it sits in a 3-generational testamentary trust, which means over the years you can sell it and have the children pay the capital gains at a much lower tax rate. Well, family home's a bit of an interesting one because if your home is subject to capital gains tax, well, often it isn't, but it can be. Even a pre-1985 family home can be subject to capital gains tax. If you ran a business on the property, for example, and you then did an improvement, let's say of greater than $70,000, you did that 15 years ago, then that asset or that new asset now becomes a capital gains tax, or part of the capital gains tax regime. Let's also look about pensions. A lot of mum and dads want to keep their pensions, and mum will open up a bank account as joint tenancy with one of her children or all of her children. That could fall foul of the deprivation rules of $10,000 every year or a maximum of $30,000 over 5 years. If you give any more than that away, the capital income is still deemed to be yours, sometimes indefinitely. So you be very careful about that. If you have a business property and you die, your survivor gets it if it's joint tenancy, and that property is pregnant with capital gains tax. Again, you or your spouse is the only one that can pay the capital gains tax on that, where if you had to sever the joint tenancy, made it tenants in common, that half, that commercial property, goes into the will and then can be manipulated through a 3-generational testamentary trust. Therefore, I don't like joint tenancy. However, there are a couple of little times you may want to consider keeping joint tenancy. One is to avoid probate. So probate costs $2,000, $3,000, $4,000 on average. If you have a joint tenancy, for a few $100s, you can have the property transferred from your spouse to yourself without the grant of probate. There's that advantage. Also, it stops mistresses making a claim. So let's say I've got 4 or 5 mistresses and I put all my assets as joint tenants. So when I die, there's nothing in the will. It goes all straight to my wife. And therefore, when the mistresses turn up and want to challenge the will, they can do that, but there's nothing in the will to challenge. So joint tenancy on the whole, I think, is a very old-fashioned way of owning property, but it can have its advantages. Enjoy joint tenancy and enjoy the use of our law firm Legal Consolidated barristers and solicitors.